Heirs property is property that has been passed down through generations. As a result, has a fractured title and does not have clear title. And heirs property comes about either through someone dying without a will and the land or the home being left to the family members, and there being several children and a spouse, and then when those children pass away, then it's passed down to the next set of children, and it can go on for several generations. It can be passed down through not having a will. It can also be created through a will that leaves the property to say 10 children, and then those children end up leaving it to their children, etc. Oftentimes what happens, and what has happened in the state of Georgia, is that a lot of people during hard economic times left the state of Georgia looking for better economies elsewhere, and so you can end up with several generations down the line, you can end up with property that is owned by family members who actually don't know each other. And you can have one family member who's stayed on the property and worked it, if it's a farm, or lived in it and taken care of the house and paid property taxes. And then you can have family members who are second and third cousins who live elsewhere in the U.S. that have actually never even seen the property, but are part owners of the property through their heir status.
Some of the issues I see with heirs property include getting everybody in the family to agree on what to do with the property. Some of the family members may feel like they have more of a say because they may have more of a connection to the property than others who may have moved away and lived most of their lives away from the family property.
The land don't have to be divided. That for one of the heirs to come in and sell their part of the property.
Yeah,
I didn't know that.
We got knowledge of that today.
Yeah, I got knowledge of that today. I didn't know that. I thought before they could sell a part of their property that the land had to be divided.
Other problems might be where any one of the owners of heirs property could sell their interest in the property and then sell their interest to someone who's outside of the family. And that person can come in at any time and assert their right to have the property partitioned. And if the property can't be physically partitioned, which means that it can't be physically divided between all the heirs, then the court might force a sale of the property so that everyone can at least get their share of the funds from the sale of the property. There are other issues where you might want to apply for a second mortgage on the property or refinance the property. That would be difficult to do with multiple heirs. Some banks or some institutions might allow you to get a signature from all the heirs to say that we agree to have this done, but others would say we want to have one or two people that we can count on to be responsible for this loan instead of having all these heirs on it. So they would want you to have a more consolidated title to the property. Okay, there's multiple ways to handle heirs property. One situation might be where you would actually consolidate all of the interest in the property into one person, and that would require all of the other family members to quitclaim their interest to the person who is going to have title of the property. So that's one thing you can do, to consolidate all of the interest into one person. Another option might be a trust, where each of the family members put their interest in the property into a trust and to the name of a trustee who would then manage the property on behalf and for the benefit of the family members. And another option could be a tenancy in common agreement. When you have owners of heirs property, they're under the law they're called tenants and or co-tenants, where each of them have a right to full use and benefit of the property, but then they also share that right with other family members. You could create a tenancy in common agreement, which is an agreement between all of the heirs to say, this is what we want to happen to the property and under what circumstances. This is how the property is going to be managed. This is who is responsible for paying the debts on the property, for paying the taxes. This is who's responsible for managing the business operations that take place on the property. So that's another option. Basically, what you would want to do is either have the title into one or a few people's names, or you want to have some kind of agreement, whether it's through the tenancy in common, the LLC, or the trust, some kind of agreement with that all of the heirs agree to that determines what would happen to the property. If you want everybody to continue to have an interest in the property, create an LLC, which is a limited liability company, and basically it's a business. And you would have all of the heirs transfer their interest in the property to the business, and so the business would then own the property. And each of the heirs would have a say in what happens to the property as owners of the business, and they might, if there are any profits to be divvied up, then they would get a share of the profits. And also they will also have to contribute to any losses that the business faces. If there's any debts that are taken out and the business is not able to pay the debt, the family members might be responsible for their percentage of that debt.
We're very fortunate to have parents, grandparents who are or were landowners. Through them owning land and passing it on, it's 11 of us, and so we said that we wanted to keep the land in the family. So that's when we incorporated. We formed a corporation, and we did it through the state of Georgia. What we do in terms of making it managed for the 11 children, we have to pay property tax on all of the land. So we are accountable at the end of the year, and we divide the taxes up in Harris County and Talbot County, and we divide it by 11. And that's how we manage to keep the land going with the property taxes. We try to, as a corporation, be there to meet family needs. Everybody is important, and everybody has a say. And that's what we have to respect. Respect the family dynamics, and you'll be able to, you should be able to make it work. If you look at your parents and you see how hard they worked to get what they had. So we were very fortunate to have legal advisors. And that's the final piece.
In 2000, my father became ill and died suddenly. I went on his word that he had a legal will. What I found out after my father's death was he started a number of wills. None of them were complete, none of them were signed. So my father died without a will. I had 3 siblings and my father, so there were just the 5 of us. There was just no discussing it with him. He had control of it, and he did as he pleased with it. So after his death, I'm stuck, basically. I'm the only person that has any interest that is gainfully employed. But definitely from the year 2000, I've paid all of the upkeep and property taxes and everything since that time. At this point, I'm not sure how it's going to be resolved. I'm kind of like out there on an island by myself, and the people who should be, working with me to resolve these issues is like they're just happy because I have somewhere to stay, and that's basically it. But my advice to anyone is to be very persistent. When there is property, family property involved, that it takes persistence, and it's not so, you may get labeled, where they just want to know, what they're going to get and make, that kind of stuff. And that's not what it's all about, because when you get caught in the situation that I'm in, and really, no support from the people who are directly to benefit from the property, it makes it very difficult.